All right, good afternoon, everyone. Welcome to ISP's August First Friday webinar, 20 Questions and Answers to Better Risk Management, presented by Reid. For those of you whom I haven't met, my name is Ariana. I'll be monitoring all of the First Fridays and other webinars from here on out. So if you ever have a question regarding any of our online events, you can feel free to reach out to me. You can call the ISP office, or you can email me at ariana@frontlineco.com. So just a few other housekeeping items. We do have the handouts and the quiz available. They're both on the website. You should have received that link in your confirmation email. They are also included on the handouts section of your dialog box. And there will be a follow-up email coming from GoToWebinar with the link in it. So if you have any problems finding this link, let me know. Hopefully you won't. Also, if you guys could complete the quiz by next Tuesday, I'd really appreciate it, just so we can get your PDHs to you out as soon as possible. So with that, I'm going to hand it over to Reid.
Awesome. Thank you, Ariana. Good afternoon. My name is Reid. I'm with Holmes, Murphy & Associates. For those of you who don't know who we are, we're an insurance brokerage. And our Peoria, Illinois office specializes in working with design professionals exclusively. We don't do restaurants, we don't do hotels. We're very entrenched in your industry, and we're always happy to have the opportunity to work and present with the ISPE. So thank you all for attending, and thank you for the opportunity. We really appreciate it. So today, we're going to go through 20 true and false questions with regards to risk management and insurance type items. We're going to identify risk strategies, develop strategies and tools to improve your risk management, improve the health, safety, and welfare of project participants and the public, and implement practice improvement programs. So like I said, we're gonna read the 20 true-false statements. I'll read a statement, and your goal is to correctly answer whether it is true or not. Since we're all viewing from different locations, you'll grade yourself. You can certainly raise your hands, as the slide suggests, during the presentation, but keep in mind that no one's going to see you, and other people in your office walking by may think you're crazy and you've lost your mind on this Friday afternoon here, so keep that in mind. So with that said, let's go ahead and move forward. Ready, let's go. And question number 1, stealth condos. From a professional liability standpoint, stealth condos are less risky than regular condominium projects because they tend to fly beneath the radar of litigious class action suit lawyers. True or false? And that answer is false. So what is a stealth condo? So it works like this. The developer retains a design team to design, let's say, an apartment complex. During construction or shortly after, the developer converts a project to condominiums without the design team's knowledge. This becomes problematic since instead of having one owner, now you have multiple unit owners on the project, and there's probably even going to be a homeowners association to contend with as well. Overall, condo projects are on the rise all over the United States. They continue to be one of the highest risk project types out there. And claim statistics tell us that it's not if you get a condo claim, but it's when a condo claim is presented to you. That's how risk prone they are. One of our carrier partners has actually shared with us that about 30% of the open claims in their book are related to condos. So they get really picky when they're writing those, and they charge premium accordingly. Condos always continue to be a hotbed for the ambulance-chasing attorneys. We hear stories regularly of attorneys approaching condo owners or homeowners associations, soliciting them for any potential issues in each unit, and sharing the successful litigation stories with them to get them to hire their law firm. We've even heard of attorneys and law firms having cookouts for these homeowners or condo owners associations. They'll actually be grilling out burgers and brats, and they'll ask each homeowner as they come walking up, hey, you know, how's your unit? Any cracks? Any issues? And they try to solicit reaction that way, trying to gain the opportunity to litigate and bring suit against the design developer, the design, the owner, the developer, the contractor, anyone who they can get some money out of for everyone. Number 2, standard of care. And by the way, if you have questions along the way, I think Ariana indicated you can type them in, and she'll certainly...
Actually, Reid, we did just get a question, so I'm going to go ahead and read it right now. Is it a design or construction quality issue, or just that there are more possible plaintiffs?
It's kind of a mixture of all three. There's more plaintiffs for sure, and the plaintiffs tend to be attorneys or doctors, or you know, people who aren't experienced in design per se, and then, you know, just the claims themselves. I mean, if it's wrong on one unit, it's likely going to be wrong in all the other ones. So it tends to be an issue with regards to repetitiveness as well. So you're not getting sued for it once, you might be getting sued for it 20 times from individual owners, or if the homeowners association is banding together and bringing suit, then that certainly decreases it. But it just tends to be a very risky project type, and again, it's just the types of clients. The ambulance chasing lawyers are actually doing the same thing with a lot of school projects and whatnot too. All right. Okay. Moving on to number 2, we have standard of care, and let's see. Committing to meet the prevailing standard of care in your contract is tantamount to giving your client extended service guarantee. True or false? And that answer is false. One of the top insurability factors we focus on for clients is examining that standard of care and to make sure that design professionals are not raising that standard of care. As a design professional, you're responsible for adhering to the normal standard of care in the industry, which is design consultants shall perform in a manner consistent with that degree of skill, care, and skill ordinarily exercised by members of the same profession currently practicing under similar circumstances at the same time at the same or similar locality. So your professional liability policy actually covers you for the prevailing standard of care. It's just mentioned there. Anything above that standard becomes uninsurable. So be very cautious when you're seeing words like you're going to perform to the highest of standards. You can perform to the best of your ability. You're going to be the most awesomest design professional ever. You know, be careful for these types. It can just be a single word that can actually heighten that standard. So yeah, always include a standard of care clause in your contracts to establish your client expectations. Hey, we're not perfect. We're going to work with you to make the project right, but we're not perfect. We don't provide guarantees and warranties, that type of thing. And be very cautious of those words that may increase your standard of care. Number 3, construction manager. In the event you work on a project as a lead designer and the owner has hired a construction manager, your professional liability risks may increase. True or false? There we go. And the answer is true. It's generally true. So now there's another party involved in the design equation, and sometimes the line of communication with the owner is now directed through that construction manager exclusively. So if issues arise with that construction manager directly, then there's issues with trying to communicate to the owner, trying to relay important information. Additionally, sometimes there's a design style or an approach difference between what your firm would normally do and what the construction manager may normally do in the course of their business. So the way you or your firm may approach a project may differ from the way the construction manager may approach that same thing. So that could create some additional conflict there as well. But just have a very clear conversation with the owner, have a client contract that acknowledges that you're hiring the construction manager, be very specific about their duties, their responsibilities, what they're actually going to do on the project. And, you know, you also state in your contract, if possible, that you're entitled to rely upon the construction manager's proper performance as well. You don't need to be on the hook for everything here. You need to be able to have the right to rely on whatever information they're providing you in the course of design as well. Number 4, geotechs. The trend toward having the geotech on a project, contracting with and reporting directly to the lead designer rather than the owner is problematic. True or false? And that answer is true. The preference is really for the owner to contract directly with the geotech. Why? Geotechnical services tend to put a greater deal of risk on your firm. Let's face it, geotech services are not exactly the sexy services on a project, and the owners would rather spend more money on architecture or structural items than on the soils. So in many instances, the owners will try to economize on geotech services to try to save costs, cut costs on those projects. But as we all know, if the soil or the ground isn't right, then the structure is not going to be successful. So we've had a pretty good example of a claim regarding, we had a civil engineer that hired a geotech, and it was a parking lot job in Colorado, and there's like a small utility shed in that parking lot. So the civil engineer ended up hiring the geotech directly, and then the project went forward. There's like a pad of concrete on which that utility shed was on. It cracked and failed, making the building on top of it fail. So our civil engineer said, "Hey, you know what? This is all the geotech," but that claim was facilitated to that civil engineer, and they're vicariously liable for their geotech as well. So they ended up getting stung pretty bad on that particular project. And to kind of add insult to injury, always be cautious with those geotechnical contracts. Almost all of them I've seen, they always try to add a limitation of liability clause in there. In this case, the civil engineer signed the geotechnical contract, and it had a $50,000 limitation of liability. So when it came down to who paid what on the claim, the geotech was insulated pretty greatly by that limitation of liability, and the civil engineer paid in excess of $1 million to make that client whole again. Again, through not a lot of fault of their own, but through the fault of the geotech, unfortunately, in this situation. We also hear, you know, that there's a counterpoint position with regards to hiring the geotechs. In some cases, some people say that it may be preferable for the designer to hire the geotech, particularly when the client is unsophisticated or has a history of being cheap on geotech services. So the reasoning behind that is that it's better for the designer to hire a qualified geotech to perform an adequate scope of services for them than try to have the client hire them directly to try to get that accurate report. So it's kind of the devil's advocate point there. Number 5, indemnities. This is always a fun one. It's acceptable to agree to a mutual indemnity agreement in your client contract. True or false? The answer is true. Our attorney partners have shared with us that their preferred indemnity path is to have no indemnity agreement in place. And this way, each party is responsible for their own share of responsibility in the claim. And it kind of goes back to the old English common law on which our Constitution is based. Their second preference is this mutual indemnity, which kind of outlines the obligations for each party. The number one item that we look for in contracts with regards to insurability is this indemnity clause. About 90% of the indemnity clauses we see, it's written in an uninsurable fashion as it pertains to the professional liability policy. Anytime you see any verbiage in your contract that states engineers shall indemnify and hold harmless, engineers shall defend, give some extra care to examine that clause. So going a little bit further, I typically look at about 4 items in those indemnity clauses to make sure that they're insurable. First and foremost, make sure that the indemnity is tied to your actual negligent act, error, or omission in the performance of professional services. That statement, that's actually the trigger for your professional liability coverage. If there isn't an actual or alleged error or omission, that professional liability may not be triggered. Secondly, kind of moves a little bit further with regards to the first one, is that be cautious of the word defend when they stick it in there. So by including the word defend, you may be agreeing to provide defense obligations for your client before that actual or alleged claim has been made, thus before the professional liability policy has been triggered. Those defense expenses could be coming straight out of your pocket directly. There's actually been court rulings to this effect where the architect or design professional is found to be not negligent with regards to the actual claim that they're accused of, but they have that word defend in their indemnity clause. And when the ruling came back from the judge or the jury, I believe it was a judge in this case, they actually said, hey, no, you're not negligent with regards to the services that you perform, but you agreed to pay for the defense costs for your client in the contract. And since that professional liability policy wasn't triggered, they ended up paying those defense costs out of their pocket, somewhere to the tune of $200,000 or $300,000 worth of defense costs. Those really add up quickly. The third thing I look for is who are you indemnifying? Try to limit who you are indemnifying. Many terms like agents can include anyone who even drove by the project or glanced over when they were walking by or something. So be cautious of that. And then lastly, the thing I look for is a lot of times you'll be indemnifying with regards to attorney fees in those clauses. And we always encourage you to place the word reasonable in front of that term attorney fees, because I don't know about you, but given no money and someone's going to pay for my attorney fees, I'm going to hire the most expensive attorney on the planet. I will seek them down. We'll get some of those California attorneys that get like $800 an hour, something crazy like that. So just use cautious with regards to those indemnity clauses. Number 6, PL insurance. It's acceptable to agree to a contractual clause that promises your client that you will maintain a certain level of professional liability insurance for the next 5 years. True or false? And the answer is false. So you can't really guarantee that someone else is going to provide a service to you in 5 years. There's some outstanding factors here that we have to keep in mind, even for the professional liability insurance. What if you close your firm? What if you decide, you know what, we're going to quit this design business and we're going to go teach at the university. We're going to close our doors and not provide any more design services. What about if the firm goes bankrupt? What if there's a merger? What if there's an acquisition? What if you have 2 or 3 really bad claims. A lot of times, if you have 2 or 3 really bad claims, your professional liability carrier will non-renew you for coverage. They have a business model based upon the amount of risk that they want to take on. And if you have 2 or 3 really bad claims or a frequency issue with regards to claims, then they're going to say, no, thank you, because they're trying to be profitable as well. So the best thing to do is you can say, hey, we'll do our best to maintain professional liability insurance for X amount of years, as long as it's economically affordable and commercially available. Here, this gives you the out. That way, you're saying, yeah, we're going to do our best to maintain this, but there may be extenuating circumstances, so that's kind of your out. Number 7, interest charges. Imposing interest charges for late payments in your client contract should be avoided because it damages client relations. True or false? The answer is false. It's perfectly acceptable to charge clients. How do you handle payments in your firm? Is there a procedure that you follow within your firm of how you collect those late payments? Be very clear in the contract and discuss payment expectations with your clients. Have a clause in your contract that establishes a reasonable monthly interest charge on all the balances that are past due. Require the client to also pay for all legal fees, outside agencies fees, court costs, internal staff costs, and other expenses related to those collection efforts. One of the best pieces of advice that I've heard with regards to collecting payments is we were listening to an attorney at an industry meeting recently, or the past few years, and he says the number one way that he has increased payments and decreased his long-standing accounts receivable is simply he'll send the invoice, and like a week later he'll pick up the phone and call the client. Say, hey, did you get my invoice? Did you have any questions about my invoice? And a lot of times he said if there was a potential issue with regards to the services provided, that kind of also gives them the opportunity to be like, hey, yeah, I understand this, but it also opened up that conversation with that client to be able to address whatever issues that they were having, or something perhaps that wasn't going quite like they planned, or maybe a potential delay or something. But just a simple pickup of a phone call said increased his receipts of those payments quite greatly. Number 8, guarantees. Because vendors who provide systems, equipment, appliances, and other goods that are part of a project offer guarantees or warranties, design professionals should guarantee and warrant their services as well. True or false? And the answer is false. Flat out refuse to include any performance warranties or guarantees for your services in your client contract. This is a major, major deal breaker. In fact, your professional liability policy actually specifically excludes coverage for certifications, guarantees, warranties. So by agreeing to this language, you may be negating your coverage under your professional liability policy, and you're setting yourself up for denial of coverage in the event of a claim. Make it clear that you are not required to be perfect. You must only perform to that prevailing standard of care. Again, going back to, I think it was question number 2, that prevailing standard of care. I'm kind of on a separate note, but very much related. We're seeing an increasing trend with regards to lender agreements coming to our design professional clients. So in these instances, what happens is your client sends you over a lender agreement and says, hey, they're not going to release funds to the contractor, they're not going to release funds to me, they're not going to release funds to you unless you sign this. Oh, and by the way, I need this by 3 o'clock today. It's a pretty unreasonable expectation for such a quick turnaround. And in many of those instances, what we're seeing in those lenders agreements are these certifications, these guarantees, these things that the bank wants you as the design professional to sign off on in order to be able to let payment out. So use caution. Some of our clients have said, hey, we've gone back and we'll mark it up and we'll send it back to the client, or back to the client and say, hey, we're not going to sign this. We've marked it up with what we will accept. And a lot of times it's amazing how long that thing will sit out there. It'll sit out there for a week or two, this thing that was so urgent that they had to have by 3 o'clock today, and they finally get around to responding and say, oh, okay, yeah, this is okay, or they come back trying to alter some language again. So just keep that in mind. I know they really try to put the pressure on you with regards to those. There's some sample language you can actually put in your contract that says, hey, I'm not going to sign anything unreasonably, that type of thing. If anyone's interested in any of that sample language, please let me know and I can forward some on to you. Number 9, privity of contract. Privity of contract, which is the concept that a contractual relationship is necessary to sue someone for economic losses, has been eroded as a legal theory. True or false? It's true. Yes, we are in the good old US of A, and the society that we live in has become very litigious. We have the freedom to sue everyone, anybody, for anything, at any time. So never mind that you were not even involved in the contract. You're going to get dragged into the claim anyway, and they're going to try to get money out of you. And unfortunately, in a lot of these instances, the cheapest thing to do is to settle that claim because it's going to be cheaper than getting hit with all the possible defense expenses on here. So it's kind of a frustrating thing. You can have your attorney examine some of the prevailing privity of contract laws and rulings in your jurisdiction to get some advice on that. You can add like a third-party beneficiary contract clause that limits the liability. These type of things you can help kind of combat against that. But unfortunately, it's just a growing trend. Number 10, commissioning. Commissioning is an intrusion into a design professional's responsibilities and a gotcha exercised by overly demanding owners. True or false? And the answer is false. We see most commissioning services used to verify and document like the performance of mechanical, electrical services and the overall building envelope. Most of the time the intent of the services is to have a higher overall quality building with lower energy use, have fewer construction delays, fewer RFIs and change orders, and to enhance the communication and reduce claims on projects. If the owner is going to incorporate commissioning services into your project, we suggest that you do this at the very start of the project and work to make sure commissioning a problem resolution, and make sure that you're working towards a solution-oriented fashion, not a blame game. Hey, they're just going along and looking for things to call you out on or find you at fault for, or say it's an error or omission, that type of thing. So just be very cautious. And again, it's having that open communication, not only with your owner, but if there's a commissioning agent being hired as well, it's having that open conversation with them as well. I'm going to pause before we go to 11 and check in with Ariana and see is there any other questions we can address at this time?
It looks like we do have one more. It may have been one from a few slides back. It says, okay. Being a professional engineer, you're already giving a guarantee. Is it true?
What? Say that again, please. Being a professional what?
It says, being a professional engineer, are you already giving a guarantee? Is it true?
No. As a professional engineer, you are not already giving a guarantee. As a professional engineer, you are going to be held to a higher standard of care than, say, the general public, but you're still only going to be held to that prevailing standard of care that all other design professionals are held to. So no, you're not specifically given a certification, a guarantee, a warranty of the services that you're providing. And, you know, I've said it once, I've said it a million times. I think one of the hardest things that you do as a design professional is trying to explain to your client what it is that you do. There's a lot of misconception, even amongst people who have experience working with, you know, engineers and architects on a regular basis. They have a false sense of what it is that the services that you're providing. So again, it's just having that open communication with your client, kind of informing them, hey, this is what we're going to do, and having that clear scope of services of what you're going to do, what you're not going to do, and what other people are going to be doing on the project is so key and so important with regards to that negotiation process, just starting out on that project.
Okay, so that looks like it's it for now, Reid.
Awesome, thank you. All right, so moving on to number 11, delay claims. Delay claims are among the most common types of demands made against parties to a construction project. True or false? And the answer is true. Again, communicate with your client. Meet regularly throughout the life of that project to discuss scheduling, how the design construction team can work to keep the project on track and on time. Point out potential delays at the first sign of trouble. The earlier that they're addressed, the quicker you can work towards getting the project back on schedule. We see these delay claims or these economic damages are frequently the highest percentage of damages when it comes to a claim. It's again, continue to manage your client expectations. Having those open lines of communication are so vitally important when things start to slip or fall behind, or you notice there's an issue. Be sure to pipe up and document those conversations with your client, with the contractor, any of those meetings. And a lot of that is also, you know, managing the client or the expectations at the onset of the project. Let's say perhaps there's a church or a retail store, and they want to have their church or store open by the holiday season. That way they can get their tithings. That way they can get they want to be open on Black Friday so everyone can go shopping and whatnot. If they're approaching you in August and they want to be open in November, is this a realistic time frame? Be very cautious about some of those aggressive time frames with regards to when they want the project completed. Number 12, BIM, Building Information Modeling. With building information modeling, where all parties to the project contribute to a common database housing all design information, the lead architect should retain ownership of the design throughout the construction process. True or false? We see the answer is true. So having one central contact during that design process to help keep track of all the different design documents on a project can be very helpful in kind of herding all the various disciplines, all the various documents on that project. It makes sense for that lead designer to take on that role. But once that project is completed, you can then transfer that ownership of the design to the client. But be very specific, only for purposes of operation and maintenance. Make efforts to prohibit the owner from changing or reusing the design documents without your written consent, and include some sort of hold harmless language in there to make sure they're not reusing or altering those documents without your express permission. Number 13, design build. If you're the lead design builder or a part of a design build entity, your liabilities and insurance requirements expand to include those of a contractor. True or false? That is true. So once you start providing those construction services, if they're in-house, or even if you start hiring the contractors, swinging the hammers, providing those construction services directly, your liability increases greatly on those projects. So now, just instead of being on the hook for design, now you're going to be responsible for the safety on the project and the means and methods used to build the project. Even having a contractor as a subconsultant increases your liability, as you're vicariously liable for their actions. So a lot of times we'll have design professionals come to us and say, hey, Reid, the owner really wants us to hire this excavating company, this air monitoring company, you know, all these various trades with regards to the project. And we have to say, hey, you know, you are taking on more liability with regards to the safety and means and the methods of what you're looking at there. So my advice for firms who are looking to do this, or their clients are asking to do this, go all in or don't do it at all. The additional costs when it comes to your insurance program are often not worth just kind of dabbling in that, because it's the biggest additional exposures to your general liability and your workers' compensation exposures. Those are the two policy premiums that are going to increase significantly. If you do wish to pursue these services, we encourage you to work with your agent or broker to put together a coverage package that's going to adequately cover these new liabilities. Also, allow them some time to seek that coverage as well. We see a lot of insurance carriers, they love contractors, and a lot of insurance carriers love design professionals. There's not a whole lot out there that love firms that don't do both. They are out there, but it takes a little time to get those terms back. So have a little patience in that process, and we encourage you to involve your agent or broker in the process early while you're considering those in your scope of services or your proposal processes. Number 14, fiduciary liability. Fiduciary liability doesn't apply in the absence of negligence. True or false? The answer is false. So the West Encyclopedia of American Law defines a fiduciary as an individual in whom another has placed the utmost trust and confidence to manage and protect property or money. The relationship wherein one person has an obligation to act for another's benefit. So this differs greatly just from your normal professional standard of care, and can put you on the hook for being responsible for the economic success of a project. Be cautious when you see design professional, when you see phrases, terms like design professional accepts a relationship of trust and confidence. Engineer will perform services in an economical fashion, or maybe even something like design professional agrees to a relationship of fiduciary. Be very cautious when you see these terms in your contract, as it can greatly increase your risk, increases your standard of care, creates some contractual liability that you're not going to be covered for under your insurance program. If you're worried about these type of things, you can certainly include a clause in your client contract stating that neither you or your subs are going to offer those fiduciary services. You can include some language, kind of like nothing in this agreement is intended to create or shall be construed to create a fiduciary duty owed by either party to the other party. Just be very cautious when you're seeing those words. Number 15, drones. or the more politically correct term is unmanned aerial vehicles. You could be vicariously liable for claims that arise out of your subconsultant's use of drones. True or false? And the answer is true. You are always vicariously liable for the actions of your subconsultants. Always make sure that your subs have proper insurance in place. There's actually a lot of insurance carriers out there that will either increase your premiums or not offer insurance coverage if you work with a large percentage of uninsured subconsultants. With regards to the drones or the UAVs, we're seeing more questions. We're seeing more firms, more people use these with regards to commercial uses. The FAA has finally pretty well streamlined the process to get your certificate and license to use those UAVs commercially. The insurance carriers now, they're pretty well on top of the issue. They now have avenues to obtain coverage easily. Want you to keep in mind that your normal general liability policy specifically excludes aircrafts. A drone, a UAV, is considered an aircraft. You have to go out there and get that FAA license to use it commercially. So it's specifically an aircraft. So your general liability policy is specifically excluding that coverage. So have a talk with your insurance agent, your broker, say, hey, this is, we now have a UAV, we're using this. That way we can work to either add an endorsement under your policy to kind of mitigate that aircraft exclusion, or we can also, there's also a separate UAV policy product available as well. But there's different avenues to approach that. And, you know, even if you're hiring the subconsultant that's using the UAV, it may not be a bad idea to check with your insurance program, see how much it is to add that coverage back into your policy, just to kind of mitigate some of that vicarious liability for yourself. Insurance carriers. For peace of mind, you should always select a professional liability insurance carrier with the highest financial rating from AM Best. True or false? The answer is false. Just because the insurance carrier is a high financial rating doesn't mean they're a great carrier. There's many other factors to keep in mind with regards to picking an insurance carrier. The policy terms and conditions specifically. Are there non-normal exclusions on the policy? Does the carrier have a history of good claims handling? Do they offer risk management services, courses, offerings, that type of stuff? Typically, with regards to carriers, we see that the more offerings, the more risk management items that they have, like whether it's webinars or seminars or contract guide resources, that type of thing, the longer that carrier is going to stick around. It's kind of interesting. When I came on board, Holmes Murphy started doing this 11 years ago. There were about 27, 28 professional liability carriers out there. In the past 10 years, now there's about 70, 72 professional liability carriers out there. So a lot of times these carriers will enter the market and try to make a quick buck, and it ends up that they don't stick around too long once claims start hitting, and they either increase their premiums quite significantly or exit the market completely.
Reid, we do have one more question.
Okay.
Would you have, for sharing, a generic boilerplate example proposal form containing statements covering your areas of concern discussed in this presentation?
Yeah, so we've got some sample agreements, and I'm happy to share those. I can share those with Ariana, or send me an email directly. I'm happy to give that information to you. As with any contract or resources that we provide. It's always a great place to start. It's got some great language, but we always encourage you to work with an attorney to develop those for something that fits within your firm and the projects that you're undertaking. It's my little disclaimer for you. All right, 17, project restarts. Restarting a project that was originally begun by another design firm can greatly limit your liabilities. True or false? The answer is false. So why was that project stalled in the first place? Was it a lack of finances? Were there unusual site conditions? Was the owner not willing to put money into doing a little bit more investigation in regards to those site conditions? Is there a client designer dispute? Do your best to kind of sort through all this stuff. And if you do take on these restarts, try to get some strong indemnities and clearly spell out the ownership of documents and copyrights. If you're working off of another firm's design documents to kind of pick up and continue the project, make sure that the owner and your firm have permission and the right-off to do that. It can get kind of messy with regards to some of those copyright or ownership claims with regards to those documents. So make sure that owner's getting those permissions specifically and some sort of indemnity or hold harmless language to protect you in case that former design firm tries to come after you as well. Limitation of liability. Limitation of liability clauses continue to be upheld in court despite attempts by plaintiffs to overturn or circumvent them. True or false? And that answer is true. Limitation of liability clauses continue to be regularly upheld, particularly in the state of Illinois. The limitation of liability can be a great tool in your risk management bag. By including this type of clause, you're essentially saying, I'm doing X dollar amount of services, so why should I have a higher liability or unlimited liability on this project? So if you're doing $5,000 worth of services on a project, does it make sense to have unlimited liability? Probably not. Anything that you can do to decrease that is a positive thing. So our attorney partners and insurance carriers always encourage you to include this type of clause in your contracts when possible to help mitigate costs in the event of in the case of a claim, loss prevention item, that type of thing. There's actually some carriers out there that actually even give you a discount on your insurance if you can successfully implement that clause in your contracts. So it is important to note that not all of your clients will accept this language. Municipalities, state agencies, school districts, these type of clients, that's typically going to be the first thing that their attorneys delete is that language. And it doesn't really become a deal breaker unless it's a very high risk project or a very high risk client. In those cases, you may wish to insist upon the language, but otherwise, again, it's just another tool in your risk management bag to kind of help protect against some of those higher liability items. Number 19, joint ventures. As a rule, each party to a joint venture assumes joint and several liability for the actions of the entire entity, regardless of which party made the error or omission. True or false? And the answer is true. Your professional liability policy provides coverage for your services, including joint ventures, but solely for the named insured under that policy, for the legal liability for the performance of the professional services. Pick your joint venture partners carefully. Although the joint venture partners can draft contract language, making them each responsible for their own actions, a third-party plaintiff wouldn't be bound by that language. So be aware of that. Have that conversation with your partner right at the onset of what are we going to do when there's a claim. Number 20. We're on the last one. Can you believe that? Time flies when you're having fun. Today, projects based on green or sustainable design are among the lowest risks available. True or false? The answer is false. New materials and processes have not withstood the test of time in many instances and can lead to a higher failure rates or higher liabilities. Be sure to communicate with your client clearly on any new materials used so they're aware of the risks that may be involved, especially if the owner or the contractor is asking for those specific green materials or processes to be used. You may not agree with the inclusion of those items. So make sure that you're getting some sort of hold harmless or at least putting in writing that you strongly object to the inclusion of these materials and try to get some sort of sign off from the client or the contractor on that. I know one of our design professional clients, they actually have, it's like a 6-page document that they will forward on to their client in the event that they want to substitute or change or utilize some sort of green material or just a plain substitution. They'll send this over to a lot of times it's the contractor that comes back and says, hey, we want to use this material because it's going to be cheaper and it works just as well and all this stuff. So they'll send it, and it's pretty intense. You know, they have to compare the warranties of the products, and they have to get down in the nitty gritty and how long has the company been in business, and it's pretty intense. And they found that when they simply just forward that over and ask for it to be completed, the substitution or new material request kind of fades away pretty quickly. As a design professional, you certainly have a good opportunity to add scope or upsell your services with regards to this green design. So, you know, always make sure to have this conversation with your client. Just be cautious when you're communicating, and you know, be very forthcoming with regards to the expectations or the possible shortcomings of the products. And with that, we have completed all 20 true and false questions. So now we've got the crazy painted face guy. He says here, hey, if you got 20 right, you're a loss prevention ace, you're a winner. You can go into the weekend, have a beverage, and know that you're on top of the world. 17 to 19, you're a star student of risk management. 15 to 16, it's pretty decent. 14 or fewer, you may need a little bit of refresher course in loss prevention. So if there's any other questions or reflections, I like how this dog here is looking very thoughtful about the world here. I'm happy to accept those now.
So it looks like we have one more question, and while you're answering this, if anyone has any further questions, you can go ahead and type those now. So I'll go ahead and read it. Have you seen lawsuits for solar panels installed on home roofs? If so, what kind of damage was recorded?
Interesting. I really haven't seen many of those come through. I know that there was a trend many years ago when they were kind of the first bout, or maybe it was the second bout, like back in the 90s and the late 80s when they were doing a lot of the solar panels. But I'm not seeing a trend with regards to the current solar panel activity. I can certainly, if you want to drop me an email or something, I can certainly look into, I'll reach out to the claims contacts and see if they're seeing anything and provide some additional feedback on that. But personally, I haven't seen anything. We're not seeing much in our agency here. And then if you'd like to contact me, have additional questions or risk management issues, or like us to look at your insurance program, you can reach me at Reid Just. It's rjust@holmesmurphy.com. And that's my direct line, 309-282-3905. Any other questions pop through, Ariana?
None that I've seen, so I think we're good to go.
Awesome. Well, I certainly thank you for the opportunity again, and thank everyone for for dialing in and listening to me on this beautiful Friday afternoon. And
yeah, absolutely. Thank you for a great presentation, Reid.
Thank you.
So I just want to remind everyone, please submit the quiz by next Tuesday, and I'll get your PDHs out as soon as possible. If anyone has any questions for me, you can go ahead and email. But other than that, I just want to thank you guys for showing up today. Hopefully we'll see you next week, or next month, I mean, and have a great weekend.
Thanks again.